Hi, it's Ron Coleman. I want to talk a little bit about the law of trademark and likeness and the right of publicity in the context of the new California law, which is quite clearly unconstitutional, which prohibits AI-generated political parodies if they're deep fakes. There's already been a lawsuit brought about that, and I'm posting this actually above a tweet to an article by Jane Coleman on this topic in Legal Insurrection. She covers it with her typical accuracy, depth, and originality. I just want to point out something that I think people should appreciate. It is true that this is unconstitutional, and this is not a trademark law, but I do believe that this is the premise of this legislation. Trademark law is primarily concerned with protecting symbols, names, and images, but it also intersects with the rights of personality, especially when it comes to celebrities, and that includes celebrity voices, and especially when they're used for commercial purposes. And there have been a number of landmark cases in this area. The most important one was in 1988. Bette Midler sued Ford Motor Company, which had hired a sound-alike impersonator for a commercial after she declined to perform in their commercial. The court ruled that her voice was part of her identity, and it was protected under California's right of publicity law. So the case didn't directly involve trademark law, but it established that a celebrity's voice can be a protectable attribute, and it can influence how trademark and publicity rights are viewed in similar contexts. In 1992, just 4 years later, Tom Waits won a lawsuit against Frito-Lay for using a voice that was so similar to his in a commercial that it was clearly an imitation. The court reinforced the ruling of the Midler case that a celebrity's voice, certainly unless permission is given, if it's distinctive and widely known, cannot be imitated for commercial use without consent. So these cases touch upon trademark law indirectly through the concept of passing off or consumer confusion. If a voice imitation is used in a way that could lead consumers to believe that they're hearing the actual celebrity endorsing a product, this might infringe on trademark principles or rights of publicity by creating confusion about the source or endorsement of goods or services. So the primary legal avenue isn't really trademark, it's the right of publicity, which protects against the misappropriation of identity, including voice, and which is very, very strongly protected in California. Why? Because California is the home of the movie studios. So recent discussions involving advancements in AI bring these issues back to the forefront. And the logic of Midler and Waits suggests that AI-generated imitations of celebrity voices could be actionable under right of publicity laws. There is an exception for parody or transformative use, as there always is. If the imitation is clear in context, if it's clear that the imitation is not really the voice of the person himself, and if it's transformative, meaning that it's used in a way that's really different from the original use of the voice, whether it's commercial use, the likelihood of confusion, these are factors that might be considered. This presumably is what somebody thought would be a good platform on which to build California's anti-AR parody law. The problem, as Jane points out, and as Ted Frank points out in his lawsuit, which is what Jane's Legal Insurrection article focuses on, is that, first of all, this is political speech, not commercial speech. Secondly, the statute purports to make a distinction for parody and satire, but it doesn't really define them, which is understandable because they are somewhat esoteric concepts, but it makes the statute really vague. The main point here, though, is that this is political speech. It's probably not confusing. And we're not talking about a right of publicity, which is usually exploited as a commercial property right by politicians, but rather it goes to their political identities. It is true that there is probably some context where using even a political person's voice in a confusing and deceptive way could be actionable, but it's a pretty good bet that the Hamilton-Lincoln lawsuit against the new California law prohibiting obviously silly AI deepfakes will be successful.
Shouldn't be allowed to have kids. I've also led the way in green energy by banning all cars that don't run on electricity. Then I banned almost all the electricity. This is smart leadership. On my watch, the cost of living and homelessness have skyrocketed, Schools are failing, drug dealers and human traffickers are pouring across the border, and poop has covered the sidewalks of San Francisco. This is the positive, joyful vision we offer as Democrats. That's why I'm enthusiastically endorsing Kamala Harris for president in 2024. She'll do to the country everything I did in California. Anyway, I'm California Governor Gavin Newsom, and I approve this 100% real message, which is a recording of my voice without the assistance of any AI whatsoever. This isn't a deep fake, and you can rest assured that it isn't, because I just signed an unconstitutional law outlawing deep fakes. No one would dare violate it. Thank you, and science bless America.